And if I had to be another person to stand up, if I think, after really going through this, and looking at the files and looking at the case, if I really feel that Karen Reed didn't do this and I have to be a voice that stands up and helps, I will.
We are expecting to learn more about the allegations against the girlfriend of a Boston police officer who was found unresponsive in the snow Saturday morning. I-Team sources say Karen Reed was in a relationship with John O'Keefe. She's facing charges including motor vehicle homicide and manslaughter.
We're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. Just feels like no one else wants it.
Just because you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
I'm going to tell you one thing. Karen Reed's not going to fold. Karen Reed's not going to give up. Defense team's not going to quit. The Free Karen Reed movement is going to continue. We will continue to raise funds for her. We will continue to do standouts across Massachusetts, across the nation, across the world to let everybody know what's going on here in the state of Massachusetts, the corruption. And we will continue to get the word out there. Believe me. Believe me. Oh, what's up, everybody? Welcome back to Let's Talk Live here on the LTL Media Channel. It is a Friday night here, and it is February 21st, 2025, and I can't believe how fast the year is just flying through. I literally look at the calendar. It's like, now it's the 21st, now it's the 25th, and it just goes and goes and goes. But that's fine with me because I hate the winter, and I always look forward to the spring because that's warmer temperatures. And as we get closer to the spring, it brings us closer to April, and we know what's going to maybe happen on April 1st is supposed to be the first day of Karen Reed's trial. So I hope everybody is doing well. We're going to go through the most recent Karen Reed hearing because I have been so busy. I'm sorry. I haven't been able to go through it, but we're going to do it tonight. It's Friday again. Spark them if you got them, I guess is what you say. I don't partake, but if you smoke the weedle, go ahead. We're going to hang out here. We're going to have some fun. But before we have some fun tonight, we have a mystery guest. Hello, mystery guest.
Hello, everybody.
We have a mystery guest in the studio. Hopefully you can hear her. Let me know if you heard the mystery guest in the chat because I want to make sure the microphone is good and we can hear the mystery guest. We'll wait. Oh, look at this. Cindy says, it's my 44th wedding anniversary, and here I am watching LTL. Isn't that amazing?
Happy anniversary.
That is so amazing. So amazing. And what we're going to do tonight is 25% of all donations that come in, we're going to donate 25% of that back to Karen Reed's defense fund. And I want to kick that off with a glorious $19.99 super sticker. We'll round it up to 1 penny. We'll make it 20. And Deborah, thank you so much for the $20 super stickers. We're at 20. We're at 20, everybody. And tonight, we're going to donate 25% back to Karen Reed's defense fund. All right. So everybody's asking if it's Nan or Nurse Kim. I'm not gonna disclose who it is, but she will be here and she will talk through the show with us as we go through the hearing. But before we get into the Karen Reed hearing, I want to bring some attention to a case that I've been following here on the channel the last couple of days, if you haven't seen it. And this is very important. This is a very, very important case because it involves multiple New York correctional officers that murdered an inmate by the name of Robert Brooks. And I encourage everybody, if you are not familiar with this case, you need to go on my channel and review all that information. These scumbags were indicted yesterday in New York. And I believe there was 6 of them that were indicted for second-degree murder. And there are some undercharges of manslaughter. And I had Todd McGee, my friend Todd McGee, retired Mass State Police, on with me last night to go through and analyze this murder video that came out of Marcy Correctional Facility in upstate New York. And these fuckers get indicted. And they get bail. We watched a murder. We watched a murder on video.
Right on video.
And the scary thing about it is this. That they didn't activate their body cameras. They thought they were going to be sneaky.
Mm-hmm.
And they beat Robert Brooks 3 times. Well, twice before he got into the facility. And then they brought him to an area of that facility where there's no security cameras, where they thought they could get away with this, and pummeled and beat him to death.
And then they were laughing in the background. You
Laughing
know it
in the
wasn't their
background.
first time.
So I'm going to show you a video, a quick video here of their day in court yesterday. And these fuckers got bail. And there's a lot of controversy about this right now. You need to educate yourself about this case.
Mm-hmm.
Go on my channel and check out the videos. It is very important. And I'm going to continue to follow this case because these guys don't deserve, these guys deserve to go down for a long time.
Mm-hmm.
And I'm going to tell you right now, and I was talking about this today with a colleague, they're going to take plea deals.
Absolutely.
They're going to take plea deals.
Mm-hmm.
And these fuckers would be out in 8 and 10 years, and there's no justice. There's going to be no justice. But let's play through this video really quick so you can get you all educated on this.
This outburst, one of many reactions that we're seeing tonight as several corrections officers are charged with the prison beating death of Robert Brooks.
Many upset with the judge's decision to set bail for all those involved. CBS 6's Brianna Sapardi reports from outside Oneida County Court with the latest.
You talk loud in real life.
At least 5
too.
corrections officers are facing
doesn't
murder
sound any
charges in
different to me.
connection to the brutal beating death of Robert Brooks, who was an inmate at Marcy Correctional Facility. 4 others are
I love
facing
reading
lesser
whatever.
crimes, including
I just-
manslaughter and tampering with physical evidence.
Careful, you're on
But
mic.
for Brooks' family and
Every time
others
something
seeking
gets
justice for his death, they feel it hasn't been fully served.
An Oneida County grand jury has charged you with various crimes, the top count of which is murder in the second degree.
It was standing room only inside the courtroom where 10 officers were indicted on charges for the beating death of inmate Robert Brooks. Dozens came out to the Oneida County Courthouse Thursday to be there to see the officers stand before a judge for arraignment. The 5 officers charged with second-degree murder include Nicholas Anzalone, David Kingsley, Anthony Farina, Christopher Walrath, and Matthew Gallagher. 3 other officers, Michael Mashaw, Michael Fisher, and David Walters, have been charged with manslaughter, while Nicholas Gentile was charged with tampering with physical evidence. Bail was set for all of them, which didn't sit well with those seeking justice for Robert Brooks, some even confronting the family of the officers. Protests erupted after the arraignment, angry that these defendants charged with murder were able to make bond and go home to their families.
This was a continuation of injustice. I never, and once in my community, seen what you release someone for murder in the second degree. I'm someone who was arrested, indicted, and wrongfully convicted for murder in the second degree. When I was arrested, I didn't get no bail.
They're going home to their families tonight. All of them. It's 2 systems that we're dealing with here. It's a system that's for righteous people and a system for people that don't look like us. So, you know, this is a step in the direction, but it's like justice delayed is justice denied.
Robert Ricks, Brooks' father, angry and emotional, had these words to say.
My question is why? That's my question. Why? Why do y'all hate us so? Why? What do we do? What do we do? We ain't do nothing. We help you build this country. We help you build it. Blood, sweat, and tears. We help you build this country. So why do you hate us?
The Onondaga County District Attorney, the special prosecutor in this case, held a press conference afterwards. When asked why bail was set for murder charges, this was what he had to say.
This is New York. If you get bail on a case, you should, after you do a novena, you know, just say thank you, Your Honor, for setting bail.
Thank you, Your
bail
Honor.
is not an issue in this case.
Bail is not an issue in this case. Bail is not an issue in this case. Bail is not an issue in this case. We have a murder of an inmate on tape. Body cam video that these fuckers did not activate. But guess what? We got you. Because 4 of their cameras turned on. There's no audio in it, but we can see their actions. And I can almost guarantee you they got a lip reader on that and probably read everything that they said. And it's in that indictment. And they know what they were saying and they know what they were doing.
Absolutely. It didn't look like their first time doing something like that at all. They were so calm and collected. Like, it was disgusting.
And Todd says, unfortunately, this is the culture. This is the culture in correctional facilities that need to change and be gutted. And I'm telling you, everybody, you need to go back and watch last night's live. It's a very important case. And we are going to continue to cover it here on this channel until we have justice for Robert Brooks. And I'm going to tell you, I'm going to give a good shout out right now. Duty Ron has been on this since day one. And this came across my algorithm. I think I initially heard about it weeks back, kind of filed it, and I wanted to see more of what was going to come out, what other information would come out of this case. Duty Ron's been on it from day one. I commend Duty Ron. He has been just as pissed as I've been about this, and disgusting. Bail set for these fuckers. Can't believe it. I can't believe it. But we are going to get to Karen Reed here. I got a couple of super chats that we're going to read. I also want to thank Jen for becoming a new member. With new members, we just do a $5. And tonight, again, 25% of all donations that come in, we're going to kick that back to Karen Reed's Defense Fund. We'll do a total at the end of this stream tonight, and we'll make that donation happen. Okay, Magic Eraser, $20 Aussie. We'll make it $20 US. Hey, Brian, it's from John from Tasmania, mate. Been unwell for some months, missing a ton. Back with a new handle and catching up on everything. Better days ahead. Much love, brother. P.S. The beard is back. Yes, the beard is back. The beard is growing. I'm actually secretly growing my hair back out. I'm not going to show you all right now because it's kind of like in that shitty stage, but we're growing the hair back out too. I was actually surprised how much hair is still up on this head. And yes, I look beautiful. I look beautiful. But thank you, Magic Eraser. I appreciate that. And then we have Gail's $50 super chat. Thank you so much.
Thank you,
Says,
Gail.
love watching your streams. Excited for Tuesday. And I'm sure Jackson Unetti and Alessi will rip the Commonwealth to shreds. I completely agree. And I know that this has been scrutinized all over the internet. And I've been pulled in either direction, back and forth and back and forth. I'm going to tell you right now, and this is my assumption of all this. And I was talking to my mystery guest about this before we went live on the air. And I said, do you actually think Karen's defense team, especially Alan Jackson, that came all this way with Karen Reed, would put Karen Reed in any position to compromise her case, to put her in any position to get her in trouble at this point, at everything they've gone through?
Absolutely not. That's absurd. He's so high profile now. Like, that would be very damaging, not just to Karen, but to himself. Like, nah, absolutely not. I do not believe that for 1 second.
And everybody in the chat agrees. Hell no, no, never. But I will say this. One of the smartest things that I love about this hearing, and I've watched bits and pieces, I've read about it. The one thing that I love about this is Liza Little getting up and talking about Sandra Burchmore and letting everybody know about all of the police officers that are involved in her case and how that wraps in all with the Karen Reed case. And because that case is federal, starts talking about the federal case. What a brilliant move. So now we've now what's the word? Inserted the federal investigation from Sandra Burchmore's case into Karen Reed's case. And what is the thing that they're trying to keep out of this? The federal investigation in Karen Reed's case. I love it. I love the move. It's brilliant. And we're going to get to hear it here in a little bit. So here we go. I'm going to pull this up. I'm going to double time it a little bit so we're not here all fucking night. But I love being with you all. And here we go. And I'm going to boost the sound like I always do so we can hear it a little bit better. Hang on 1 second. I just got to stop this. I'm going to bring this down here for a second. And again, 25% of all donations that come in tonight will be donated back to Karen Reed's defense fund. If you want your chat read out loud, send over a super chatty and we'll do it. We will do it. All right, we're going to boost this up. We're going to play through. And here we go. Here we go.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson.
If you need
Good morning, Mr. Jackson.
Good morning,
comment, just stop. And we'll
Good morning, Ms. Little.
morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, I was told counsel wanted to see me at sidebar.
We're going to actually go normal. So they're going to go sidebar right away. Good. All right, let's get through the sidebar.
All right, so that motion.
All right, here we go. Everybody's asking if we're going to see the guests.
So
I'm going to hold off. Maybe at the end.
Maybe.
Maybe at the end.
Maybe, if you're
Maybe at
lucky.
the end. If you're lucky.
what I'd like to do is start with, now I don't know if you all have the paper numbers on these. You probably do if you've been looking at mass court. So Commonwealth's motion for records, WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
Everybody's asking, they're saying, before we get into they're saying her voice sounds familiar. It's not SD, is it?
No.
Okay. Kelly Reed?
No.
Okay. No, you're way off.
You have heard me before, though. You have
Heard
me.
her before, yes.
Yep.
Yeah.
I spoke
Probably
to
gave
Mr.
it away.
Albano.
Not Meredith, it's not Dean.
Last week and again last night.
Okay.
And on behalf of Fox, Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until
Not Olivia
March 1st
Lambo.
to receive all of the information. I expect they'll file it with the court.
All right, let's do this really quick. Nurse Kimberly from Kansas.
Wow.
That is a new membership. So thank you so much for joining. We'll add $5 to the total at the end. It is not Jess Machado. It is not Nan. It's not Video Jesus either. It's not.
Okay.
And so
I
with the
think-
court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay.
All right, Terry, thank you so much for the $25 super chat. She says, the channel and free Karen Reed. Thank you. It's not Nurse Kim. She's not a lawyer. I love this kid.
I will.
This is
So
fun.
March 1st before they can get it here? Was that the date you
They'll
said?
have it on or before March 1st.
Okay.
Not glamour. We're batting 1,000, everybody said.
All right, so that motion is allowed by agreement and
Jill Daniels, yes, of course.
the order is right here, Mr.
Jennifer McCabe, yeah.
Not Jen Altman.
All right. Next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do
Not
that,
Haley.
right? On the 10th of February.
Not Bev.
Okay. All right. So paper number 483. This is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number?
Ryan S., thank you so much for becoming a new member and supporting the channel. We're going to add $5 to the total. Everybody's saying, is it Mizzy? Is it? It's Paul O'Keefe. It's Paul O'Keefe, actually. He's giving me glazed donuts. That's who it is. It's Paul O'Keefe's glazed donut. Yeah, that's what it is. It's not Meredith. It's definitely not Meredith. It's not Mizzy.
No.
It's not Britt.
I am originally from Massachusetts. Yes.
She's originally from Massachusetts.
arts.
It's not Karen Reed. Definitely is not Karen Reed. It's not Jen Root. The way she breathes sounds like she's smoking.
I've been sick just like
She's got the same thing I
Brian.
had. And no, we did not make out and make this happen. I've been sick, and then
I got sick at my
so
job.
I think people are starting to tune in. I don't know. Maybe we'll let this go. It is Taylor Swift. Yes, it's not Kelly Reed.
I do love Taylor Swift.
Yeah, she does. She is a Swiftie. All right, let's play through.
Okay.
Play through some more. Let people. No Fall River accent, Maddie Kate said. No weird Fall River accent. Let's get it right.
Defendant's motion to compel production of a forensically sound copy.
It's not general.
We'll get started in the argument, and you can give me that.
506.
Great, thank you.
That's the response.
Right. Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Mr. Jackson. How's the sound? Can everybody hear the video all right? I can boost it up a little bit more.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions.
Right here. Nan is here. Nan's in the chat. And she goes, I love this game. Nan's not here.
Hi, Nan.
Nan is not here.
Mr. Brennan after court the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud.
Let them know.
We were told that this was an account.
It is my friend Lauren from DC.
Hello, everybody.
She's hanging out. She said, she goes, remember like a couple months ago, you said like, I come in and watch, like you do a live. I said, yeah, you come in and watch me live. And she gets here. I'm like, you're not going to sit here and watch me for 2 hours. You're getting on microphone. She's like, all right, I'll get on microphone and help out tonight. So
I did not expect to be the mystery guest tonight, but hello, everybody.
Yes.
Again, I was the mystery guest back when we did that standout.
You were.
I remember. Yeah.
Yep. You were the mystery guest then. And if anybody doesn't know, Lauren actually did the first free Karen Reed standout in front of the White House. That's pretty fucking cool.
Yes, we did. We had a little group of people, and we're actually thinking about doing it again a little bit closer to the trial down in like later in March. So keep an eye on the Facebook group for more about that.
So everybody says it's a dreamy voice. They thought that she was AI.
I am not AI.
Yeah, she's not
but
AI.
Thank you.
But she, she's up here. She's chilling. She's hanging out, and we're gonna go through this live tonight.
Of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we did not need. We told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present. If all the information was a download from some iCloud account, unnamed iCloud account, as long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We're predicating that on a conversation that we had with Mr. Brennan in January, January 22nd. He indicated that he went to Canton.
I hate to keep pausing this, but I'm gonna get this. Free Karen Reed, Fab 5 for the win. I like that. $5. Said, did you by chance see the Young Jerks show with the North Carolina retired officer? It was awesome. He knows Karen is not guilty. I have not seen that. Maybe I did. I don't know, but I'll definitely go back and watch it. And I love Mike, and I support Mike. I love his channel. We've been doing a lot of things together lately, and we're going to be doing something pretty soon. Oh, by the way, Sunday, check this out. Double dipper here on LTL in the morning at 10 a.m. I'm going to have a live with Tom CPU and Boston Mike. We're going to catch up. It's been a while. We're going to do that one virtually, but at 2:30 p.m. on Sunday, Mark Mazza Media will be live here in studio, chilling on camera, chilling here in the studio. We're going to have a lot of fun. So double dipper on Sunday. I can't wait. I can't wait for that. All right, let's get back.
PD, the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department.
Right there.
And found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little.
Just want to answer this. Lisa T says, imagine if all the YouTubers that cover the trial would do the same to donate 25% or another amount. That would help a lot. Brian has been doing this for months. It's really generous. So I choose to do what I choose to do on my channel. What I feel right is in my heart. Okay. And that's why I've kicked back a lot of my donations to Karen on the channel. And whatever people choose to do on their own channel or in any way to raise money is the way that they do it. And I can say that there are a lot of generous creators out there that do a lot that in their own creative way to do things. But this is just something that I've chosen to do. And other various things too. Like we just had the two posters, the signed posters of Karen. Nick Rocco was phenomenal with auctioning those off. I think the first one got $2,500 and the second one was like $2,000. So I mean, that's $4,500. Like that is great.
Yeah.
And it goes right towards the defense fund. But listen, again, I know there's multiple creators out there that have donated a lot of money, just like myself. And they just choose to do it in whatever way they're going to do. On this weekend, we're going to be doing a lot of fundraising as well too. And I know Maz is doing a show on Tuesday, and I'll be on his panel, and we're going to do a lot of donating on there too. So, you know, people choose to just do it in whatever way they want, and that's their business. I just worry about what I do here on LTL. So, okay, let's get back into this.
Sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement.
An odd position. Nope.
We videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion.
All right, real quick. I'm going to stop this. Oh, look at this name. Yes, Jen McCabe. You searched it at 2:27 a.m. I love that.
Great.
The Aussie's checking in tonight. That's $8. We're going to make that $8 US. And just want to thank Paulo Griff for helping me lose weight because I never will eat a glazed donut ever again. Yes, glazy donuts. Maybe I'll get some glazy donuts for Sunday and I can eat some glazy donuts.
You and Mazza.
Well, me and Mazza will eat some glazy donuts. The Chicken Wing King will be here. I love it. Okay, let's go.
Which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR.
So I'm feeling here, and I'm sure the audience is going to agree with us, that they have a real sticking point with the Sallyport video.
Oh,
they
yeah.
really want this. And I think you're going to see a lot, if they get it, or whatever form they're going to get it in, if they obtain this video, which I think Jackson knows they're never going to fucking get it, because it's pieced out and it's cut up. And how do you even know what's going to be the original video? But I think that if there's ever a possibility that they do get this, this is going to be, and believe me, this video is gone. But I'm saying, if they were to get this, this is really, I think, where they're going to weigh heavily in 2.0. I think we're going to hear a lot about it. What do you think?
I think the Sallyport video is a key piece of evidence, and I would love to see them be able to access it. But again, like you said, we don't know if it'll be the original. It's all cut up and edited. So unfortunately, I don't think they're going to have it, but it's a key piece of evidence.
It's gone. And I want to see Higgins. I want to see every move he made in and around that facility around that time. I want to see if he moved cars. I want to see him talking on his fucking cell phone. That's what I want to see, because we know he made a call at 1:30 in the morning. Who was he talking to?
Where are the videos?
Where are the videos?
Like Esty was saying. When
where
she
are the
showed,
videos?
I watched her live the other night, Esty, and you were talking about the video at the Canton Police Station, and you were yelling at them, "Where's the videos? Where's the videos?"
Yeah, Scott, good point. He says we will never see the original uncut Sallyport video. It's gone. It's pieced. Rebecca Tucker, thank you so much for the $25. We're going to add that to the total, and we'll kick back 25% back to Karen Reed's Defense Fund tonight. All right, let's go.
Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, "Are there any original files that are in the possession of Canton
Do you want to
PD?"
wait to everybody?
The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed
a little
Ms.
under the weather. I'll do it. But I'm not going on
to
camera.
tell our expert,
Fine.
I wasn't.
get it from the defense.
Yeah.
Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that, in fact, it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information. It's exculpatory information. The audit trail is also Brady and exculpatory, because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files.
Good point.
The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that, because we would think that, in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
Mr. Brennan.
Here comes Mr. Swarmy. Spanky. Spanky Brennan.
It seems like another effort to portray some type of injustice brought upon the defense, that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR NVR where they full well knew that I had no idea if there was still video on there, and why would they be 3 years later? And after they filed a motion making representations that weren't accurate, I no longer had the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the
How fucking hateable is this guy? Like seriously, no. I'm sitting here. I'm going, how fucking hate him. So if I was to do a scale from 1 to 10, all right, let's put both of them up there. Let's put Lally and Spanky. Okay.
Oh, that's tough.
Okay. Scale from 1 to 10. Lally, what's your vote?
Oh my God, like an 8.
An 8. And I want to see everybody in the chat. Lally, scale from 1 to 10, the fucking hateable scale. What would you put? The hateable scale for Lally. You said an 8?
I mean, I want to go 10, but I mean, they're both terrible.
They're
Both
scumbags.
I hate listening to Hank.
They're both prosecuting an innocent woman.
Mm-hmm.
Okay. I think for Lally, for me,
he seemed really incompetent.
he's very incompetent, in my opinion. In your opinion.
And Hank's just really annoying to listen to.
Yeah.
His voice.
Lally, oh man. I just think for him, for me, like all the little like ticks and the smoking. So it's a little bit more like goofy about him.
Mm-hmm.
You know, like you almost kind of feel fucking, I don't know. I don't want to say like I feel bad.
Yeah, a little
but
bit.
like you kind of like, all right, Lally, for me, 7, I don't know, 7.5, 7.5.
Means up there.
All right, Hank Brennan.
Thank you, Beck.
Spanky. The hateable scale. Lauren, what would you put him at?
Oh, a 10.
That motherfucker in my book is a 12. I fucking hate you. I hate you so much. 12. I'm at a 12. Everybody's like 10, 11, 100. I'm saying 12. Oh, I hate him so much. I hate him so much. Let's get to this super duper chat before we start. Bex, thank you so much. A lot of Aussies tonight.
Yeah.
Aussie checking in. $50. This replay crew here. No, we're live, baby. We're live right now. And thank you so much for the update on Robert. That episode was heartbreaking and so needed. Keep doing what you're doing. And it is. You all need to go and watch last night's live with Todd McGee. That's a very important case. How about Bev? And we could sit here and do it all night, but I just wanted to compare both of them. All right, here we go.
Memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process. And I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petra, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sallyport area, he would download it. And what he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the.
Like super passive aggressive.
Yeah, he
I
is.
fucking hate people like that.
Yeah.
I hate, like, I feel like he's going to be like, he's like the type of person's like, I'm not trying to be aggressive.
Yeah.
When people say I'm not trying to be aggressive when they're talking to you, they're being fucking aggressive.
Yep.
I'm not trying to be aggressive here. Yeah,
Yep.
you are. You are, you dick.
It's like when someone
that's
says,
totally what I get from this guy. Super passive.
Detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about
Super
that. Can you
condescending
wait?
too.
Yeah.
I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag.
So a video that got torn up and manipulated and inverted, they're saying that the original video is what we saw. That's essentially what Hank is trying to say here.
Yeah.
That is the original video. So 45 minutes of missing video is part of the original video. And then the inversion is part of the original video.
No way. No way. That's bullshit. No.
I'm sure you could give that video to Microdots and they could fix it. He probably could fix it and make it the correct way. Unbelievable. Unfreaking believable. All right, let's do this. Nurse Kimberly from Kansas. I love that name. That's cool. And she gave me a $19 super sticker. We'll go to $20 and 25% of your donation tonight. We'll get back to Karen Reed's defense fund. And we have another, let's see. Phone Penny became a new member. Persephone Penny. Thank you. My reading comprehension is terrible.
No, that's okay. I just like that name. So.
Yes, and we have Dark Willow with $1 super chat. Let's do this. We'll round it up to $5. Let's do that. Thank you so much. All right, let's keep going here.
Drag it to a hard drive and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation.
So
said we would simply copy the video.
Reminds me of
and
a
then
rat.
as another measure, which was unnecessary, we'd actually videotape it. So we did that because the defense wanted us to, and also it seems if it's on videotape, it can
Like
limit
he's still sick.
baseless allegations.
Can't get
later,
over
so we were
something
happy
too.
to do it. And then when we got back to the office, the request changed. Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant.
I'm going to tell you something, and I'm a little bit of an amateur here, but I'm going to tell you, anytime you take a video or a photo, there's metadata attached to it.
Yeah.
I think that's pretty common knowledge. It's so good that your iPhone can actually tell you where you took that photo and get it a GPS coordination as well too. I'm going to tell you right now, with security cameras and DVR systems, I can almost 100% tell you there's metadata in there.
Absolutely. I just recently found out when you send someone a picture on iPhone to iPhone, you can get all the metadata off it. You can see when they took it, where they took it. I did not know that until recently.
You can do it with like all these high-powered cameras. If I was to take a photo and I put it into an editing system and I look at it, all that metadata is there. All this video that I'm recording right now and being uploaded, there's all metadata to it.
I downloaded an app to remove metadata from photos if I want to send.
See that? What she's doing?
Yeah.
She's trying to not disclose where she is. Dark Willow, $5. Thank you so much. Said, I didn't do that right. Brennan equals Peter Pettigrew? Who's
Peter Pettigrew? It's a Harry Potter thing.
Oh, okay. I don't know.
I'm going to Harry Potter.
We'll give them. We're obligated to give them. The only delay has been because they've asked for all these different accommodations and different styles of doing it. And so we want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes
just gifted
complicated.
5 membership.
Not a complicated process.
5.
So we'd like to
Thank you so
finish
much.
our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
So
How quickly can you do that?
I imagine we could do it one day, but today is.
Oh, Robert Les is going to get up.
You want to make, I'd be heard briefly.
Yes.
Very, very briefly.
Take your time.
Thank you. Mr. Brennan's confidence notwithstanding.
I want to thank my moderators for being in the chat tonight. I appreciate you all. Mizzy, it's been a while. I've been seeing your posts. You had an article today that you posted that explained Farwell's, essentially broke down Farwell's hearing. And I think you actually posted a photo of him, a still photo from him actually being on camera during his hearing. And we appreciate that because we had to keep this scumbag out there and let people know what he did to Sandra Burchmore. And it's funny. He looked pretty comfortable in that cell in the background. He had all the stuff up there. It's like, he's like comfortable in there. Pretty sick.
Thank you, Mizzy.
Yeah.
I don't know how to change the settings in my phone, so you'll have to send me a message or something about that.
All right, let's keep going here.
What his level of confidence is. I'm more concerned about his obligations.
Yeah, I shouldn't have been feeling well. Oh, I'm sorry about that.
Mizzy.
I haven't been feeling well either.
Yeah, I got.
He really didn't talk about the metadata
like 2 weeks ago
in his argument. He didn't talk about his the metadata in his written presentation, his opposition, because he knows that we're entitled to it.
Is SD right there in court?
One thing I
Red dress on.
Oh yeah, there she is.
This is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So,
Job, thank you. $20 says, thanks for all you guys do. Question, when is the motion to dismiss supposed to be filed? That is supposed to be, when did she give them to? The 27th or the 21st? Thank you. I thought it was the 27th or the 28th because that was the previous hearing that she gave an extension. But the 21st was today. Would be today.
That's today.
Right?
Yep, today's the 21st.
Today's the 21st. But I thought they got an extension, and maybe someone could clear this up. I thought it was by the 27th or the 28th, and I could be wrong. But remember, I'm supposed to remember all the dates and times and all that, because apparently if I don't do that, I'm not a good creator. I don't know. By 11:59 tonight. So Commonwealth's response today, but the Commonwealth's response was the 28th. Got it. Thank you for clarifying that. Apparently, if I don't remember all this, someone out there says that we're bad creators. You know how many dates and times and everything we have with all of this? Holy
even
smoke.
if it's a drag and drop, makes it sound
Commonwealth
super
has the
simple.
28th.
That electronic drag and
You're
drop
close.
will have metadata associated with it. That hard drive, every time
Thank you,
it's
everybody.
accessed and the data on it is accessed, also will have metadata.
Good stuff sometimes.
Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive,
Top
or
tip, thank you
server,
for becoming a new member. Thank
every
you.
one of them have metadata on it. So it's not difficult. We're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here.
I love this.
Again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video.
How's that fair?
Where did that one come from? Then on October 24th,
Love
we
this.
get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these?
Yes. Where's the videos?
Show me a video.
Brennan should want the
October 24th. Did that video come with the metadata?
No. No, it's just video. It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive
manipulated
storing video files, my understanding, and again, I'm no expert.
to make
My
the point.
understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to
That will
play
make
the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it, and then there's going to be the file. So that's what we're asking for. There's metadata associated with all those things. It's not a hard ask. It's not a heavy lift. There's no reason to justify.
They want to see if the
I'm just
video
gonna drag and drop this
and make the point that this video has been manipulated. That's why they want the metadata on the original video.
Any further response, Mr. Brennan?
They're going to
There
prove.
was no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to
Aaron
the
just
actual
laughed.
hard drive.
He said, we're not
and do it
depriving the
themselves, and
defense of
they found it.
anything.
Yeah.
So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can.
He was like pissed.
Yep.
If they want to come, they're
Lying.
invited.
Like he's lying.
Court wants me to inquire of a retired sergeant detective about metadata, I'll do that, but the issue is going to become that when we drag and click these videos, and if there is no metadata or logs of what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the videos. What more can we do?
Wow, Jackson's really
Invite
you know, he's
defense
rocking back and forth.
to come into the Canton Police Department and take a look at the system. So if there's something they want, then we'll copy it.
Okay. Thank you very much. All right, Ms. Giannetti, the next one should be fairly quick and simple. The motion for Prohac Vici. I asked you before when Mr. Alessi joined us, you have a rather vague good cause exists to grant this motion because Mr. Betterow had, is that how you pronounce his name?
Yes.
Like he doesn't know.
Like she doesn't know who that is. Give me a break. You got to be kidding me.
Wow, Auntie Bev.
Defendants in matters of this nature. I asked you last time what you mean by that. I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have
Real quick. So basically, she's going to most likely approve Mark Betterow to be on the team.
Yeah.
I want to make a point here. From what I've heard through some sources, is the team that you see at the table, you're probably not going to see all of them if this goes to trial and once Mark gets approved, all of them all at that table at once. They're probably going to rotate some lawyers out. One, for room. Two, these other, these lawyers have other cases as well too. They're going to probably try to make the, the point to be there. But from what I've heard is you're going to see most likely some of them rotate out where they may be, their job is to hone in on a specific point in this case. Let's just say they get the Sallyport video and let's say it's Robert Alessi's job to break that down and do the cross. I'm sorry. Do the examination of that. Again, you might see Betterow where he attacks evidence. He comes in, and that's from what I understand and from what I've heard. So, all right, let's keep playing.
Yeah.
Thank you, Your Honor.
Okay, the next one's paper.
May I be heard briefly?
Yes.
May I be heard briefly?
Yes. So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay.
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right.
Here we go. It's going to be the
And
terrible
I don't
stuff
think the
now.
Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney.
Oh.
And that is something
I haven't
that
heard
think
this
the
yet.
court should consider and be thoughtful about
Why?
for a couple
Why?
of reasons.
Oh, tell us.
There is a
Please,
history
Let
of
us know.
symbiotic relationship
The
between
symbiotic relationship.
Ms. Reed and Mr. Kearney.
Symbiotic.
There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case.
Bullies.
Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow is representing him for. Now, it's not great clarity,
got
but
Runkle
it's
on
been
his-
represented that there is a relationship
He's got Runkle on his.
between Mr. Betterow,
He's not even saying his
Mr.
name right.
Bradle, who's Mr. Kearney's other attorney, and the defense attorneys in this case.
It's Carney, by the
There's
way.
a
Yeah.
record that has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradle, have an understanding with the defense attorneys in this case. That there's an ongoing, long-term, implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious that that relationship exists and the nature of that relationship. It's not something.
So a reporter, an independent reporter that's writing stories is not allowed to go out and ask people questions.
Mm-hmm.
And because that's witness intimidation. But any other case that you can go and do that, a reporter can go out and go to a public street and talk to someone or go to a public park, wherever this person is, and you have every right to walk up, identify yourself as a reporter. I'm an independent journalist. My name is Aiden Carney, aka Turtle Boy, and I want to ask you a couple questions.
What about the Gabby Petito case? The way everyone flooded Brian Laundrie, whatever his name is, the family house. They flooded the street with people. That was okay.
Or how about this? The Long Island auditor went out to Farina's house. Farina was walking in his driveway. Farina was walking. This is one of the CEOs that just got indicted in Robert Brooks's case. The Long Island auditor, Sean, went out to Farina's house on a public street as Farina was walking to his house up his driveway and started asking him questions. Are you part of the beat up squad? He didn't get arrested.
No.
Isn't that funny? That. He's a reporter. He can do that.
Interesting.
Unbelievable.
Isn't that curious?
Unbelievable. I think I just saw in our super duper chat. Gary Johnson, $20. Thank you so much. Says just sending a chat to donate to Karen Reed. I appreciate that. And 25% of all donations tonight will be kicked back to Karen Reed's defense fund. Shall we play on and hear more about Turtle Boy and how they're colluding in all of this?
Play on.
It's so ridiculous.
That I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation of protective orders in this case. And the discovery in this case was provided to special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery. And much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage. And I am worried, and I have good reason to be worried about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this
He's
information,
getting a little upset
if a court
for
order won't
Hanky,
protect it,
Yes,
then
every
nothing
right
will. And nothing will.
but not Turtle
And
Boy.
so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each.
It's a good point, Kelly.
And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case.
Is Bettero volunteering on this case? I don't care either way. Just curious. $5 from Britt. I don't know the financial agreement of that. As you heard that during the Ted Daniel interview, they said basically the lawyer team that is there now is not taking any salary or any compensation, and that most likely will get all worked out at some point. Not my business. All I know is that we're here tonight. We're reviewing the hearing, and we're going to donate 25% of all donations that come in tonight back to Karen Reed's defense fund. But thank you for the question.
It doesn't. And that concerns the government. And so while I do not object to Attorney Bettero, they should have as many lawyers as they want. I think the court should have some caution and some concern, and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it, and whether protected information was ever shared prior to Mr. Bettero presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know.
If Nan's still in the chat, I have a question for her. She's a lawyer. Wouldn't that be like attorney-client privilege?
Oh, that's a good question. It could be.
Like talking about, oh, well, we need to find out if there's shared information and information's been talked about. Wouldn't that be under the rule of attorney-client privilege? Maybe she can answer that for me. Yeah. Kathy says 100%. Let's see what Nan has to say. Not that I'm discounting Kathy, because I think I agree. She said, yep. I mean, fuck you. You don't need to know what I'm talking about with my client, right?
Yeah. It's like HIPAA kind of, but for lawyers.
Exactly. And I think like even the church has stuff like that, like whatever you say.
Oh, really?
Yeah. I think
and like confessions
and stuff. Yeah.
That's true.
Describe the relationship. I'm asking the court to consider assuring itself
confidentiality, you know,
of those safety measures, because this trial is going to happen.
Doctor patient.
These witnesses should be able to walk into this courtroom without fear, without bullying, without abuse, and that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial. And the witnesses are entitled to walk in this courtroom without being abused. Thank you.
Okay.
We just passed 37,600 on the channel. Thank you all so much.
Ms. Giannetti, I have to consider everything that was just said, but
I don't know what this country is. NZ. I don't know what that is.
New Zealand?
Maybe.
I think so.
Could be. But I appreciate the $5. We're going to get $5 US. Says, oh my God. Watch Aussie Insider on judicial immunity. Holy fruitcake. She raised huge issue via fanning. Have not seen it. But thank you for letting us know. And I appreciate your donation.
I'll wait for your affidavit.
Right. We'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one I believe is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio.
He's got Emily D. Baker up on the screen now.
Oh, I see. Relatively straightforward, but I'll hear you, Mr. Brennan.
I wonder if he's listening.
Ronnie, you provided us the full audio. between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because
And
I
made a
like to
good
use
point
many
in the
parts of
chat.
the trial.
The
The order.
Commonwealth is not entitled to a fair trial. The defendant is.
Defendant is.
Yep.
Yeah. Commonwealth is not entitled to a fair trial. FYI, the defendant is. That's a great point. You know, their job is to bring what they think are the facts forward, and their job is to prove that the defendant did this.
Yep. Beyond a reasonable doubt.
Beyond a reasonable doubt.
Order was all the attorneys could
A lot of
listen to
reason.
it. I can report none of the attorneys have listened to it.
Reasonable doubt. Oh, yeah.
It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Excuse me.
Okay. There's no objection to this, is there?
No, Your Honor.
Of course, I'll provide a copy if you want.
Yes. All right, so this is allowed. All right, so the next is paper 490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at One Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from attorney Mark Diller on behalf of the O'Keefe family in response to Defendants Rule 14 and 17 motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at One Meadows Ave in Canton to conduct independent testing and analysis. I
Interesting.
assume counsel has seen this affidavit of Mr. Diller?
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today. And today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us. And I would ask that the court take no action on this motion until we've had a chance to view them. And we may not need to have action on this motion.
Okay.
So what I'm understanding is, damn it, I think I know the name of this camera. It will come back to me. Ferro. I think it's called a Ferro camera. And it looks like a camera that's up on like these tripods.
Yeah.
Okay. And what it does, it's a 360-degree camera. So they can use this, and it has a laser, and it will like, so if you have a murder scene in a room, like if there was a crime scene in here, they can put that in the center of the room. And what it will do is digitally 3D scan the room, and then they can bring it up in some software, and it will literally look like the room. It will be impressive. And what I'm guessing is Faro, F-A-R-O, guessing what they're talking about. And they did. And Mary makes a good point here. They did use them in the Koberger case. What they probably did was went out and used this particular camera like this and scanned that driveway. And that's what Yanetti's actually talking about right now, that they received that, whatever the photos, the 3D photos on a drive. And that's probably what they did. So, yeah. And they use them a lot. Yeah, they use them in the Idaho murders. Yeah, I've known about these for quite a while. But that's very interesting. Let's get to this super duper duper chat. Piney Woods, Law and Crime, thank you so much for the $20. Says, yes, that information is privileged, or most of what he mentioned. I'm a retired lawyer of 30 plus years, and I know enough to be dangerous. Your Venmo, Terry. Oh, thank you, Terry. I appreciate that. I appreciate that. And thank you for being here with your 30 plus years expertise. So when I know you're in the chat, I can ask you a law question and you can figure it all out. Because I'm just the dumb guy with a camera and a microphone. What do I know, right?
We love lawyers.
We love our lawyers. All right, here we go.
I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested. Okay. All right, so no action taken.
There he is. Lazy
Watching for the-
daisy
So
donut.
next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial, whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses. And that's what we're asking the court to reconsider. It is our position, Judge, that, part of, and I believe I quoted a case on the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to Ms. McCabe, it was never mentioned anywhere that she spent an hour at the personal home of Mr. Lank. From the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data, which revealed that that meeting did take place. And so, the Commonwealth with that information.
Did take place.
Did you just hear what I just heard?
Probably.
Let me go back a little bit here. We got a while ago. You gonna be okay?
Yeah, I'm fine.
Right. Listen, see if you catch it.
Okay.
I wonder if the chat caught it.
Of that very legitimate exercise of confronting a witness.
That's okay.
And surprising them with an inconsistency in their testimony. With regard to Ms. McCabe, it was never mentioned anywhere that she spent an hour at the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data, which revealed
metadata. There you go.
Geofence data. So do you know what that is?
What's the difference?
I'll explain it.
Okay.
So you and I are sitting here. Your phone is right there.
Yep.
And my phone is right here.
Oh,
it's
it
creating
can tell
a circle.
that we're next to each other.
So you know what that means? They're starting to narrow in on where all these people were.
And how?
Oh,
that's very interesting.
Oh, I like this. We got you. And they're going to know where everybody was.
Yeah.
So I wonder if, they said we were provided geofence data. Well, who they provided that geofence data by? Was it the feds? Probably.
Might have been.
Oh. Well, looky what we hear. See, it's why you gotta really listen closely to this stuff, because it will pop out and he got you. We got you. We know where you are. Yeah, that's very good. That means that they'll be able to start locating where everybody was at the specific points. Oh boy. And according to John's Apple Health data, he was in 34 Fairview. And that's going to show his geofence data And there's going to be a lot of answers. They're going to need a lot of answers from those people from 34 Fairview.
Oh, yeah.
All right, let's go.
That meeting did take place. And so the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came
And real quick, I'm just going to answer Jackie. She asked, is geofence data similar to when a cell phone pings off a tower? Yes. And what you can do is I would encourage you to go watch the Alex Murdaugh trial. There is a federal agent that testifies during that trial. It's only about an hour segment. I would go watch that because he does a masterclass during that testimony. And they literally got Alec Murdaugh down to inches of where he was in those dog kennels. And that's what essentially convicted him, because we knew about that Snapchat video. So it's brilliant stuff. Go watch that. I've actually played that on this channel before when we talked geofence data in the Idaho 4 murders, because I wanted people to understand what that was. It's a masterclass testimony. I don't know the guys with the name of the gentleman that testified, but you can look up like Alec Murdaugh trial, federal, I don't know, geofence data, and it probably will pop up. It's about an hour-long testimony. Very brilliant. And everybody in the chat did see that. They said excellent and it's brilliant.
Up with
all right, let's go.
A very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. And secondly, with regard to the juvenile witness, as the court remembers, I'm sure from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. So when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident.
They changed it a little bit more here now.
What was done behind the scenes to arrive at that conclusion as well. And I also include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed. So I take responsibility for everything that's in there. But we also make the point that with regard to Trooper Proctor, it appears as though there was he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument, and he obviously uses derogatory language toward him as well. If we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but this is I won't say unique trial, but it's a rare trial that is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with. And to the extent that we turn over this impeachment material and the Commonwealth uses it.
What was the order? And maybe a lawyer can clear that up for me in the chat. I want to go back. He said something about sequence order. I don't know what that is. Let's hear.
There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders.
Sequestration. I'm probably got that wrong.
Sequestration. I don't know what that is. We need a lawyer.
What is that? Help me out.
Sequestration.
Everybody's so smart in the chat. Thank you. What is that? I've never heard of that.
Wait, that sounds kind of like sequestering a jury.
Watch. Oh, sequestering the jury.
Okay. Context
could
clues.
be. Jen's saying it means can't watch.
Yeah.
Not allowed to watch to trial. Yeah. Okay. Look how smart everybody is. I'm dumb. Witness Nan says witnesses are not supposed to be watching trial. Oh yeah, of course.
That makes sense.
Makes a lot of sense there.
Sequestered.
Not allowed. People testifying. Thank you for clearing that up. Because I was like, what is that? What is that?
We don't know
I
for
learned
sure
something
whether they've
today, Lauren.
been
Me
complied
too.
with. And to the extent that we turn over this impeachment material and the Commonwealth uses it, it's another opportunity for a witness to see potentially in advance something that could otherwise be.
No, you're fine. You're just not a lawyer. You're not dumb. You're just not a lawyer.
Well, everybody in the chat knew it was.
I didn't. I have a master's degree and I didn't know what it meant. So I have a different area of expertise.
Understood.
All right, so, Mr. Brennan?
Excuse me. Oh, here we go.
I think I take a minute, Your Honor, and talk about this.
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush.
Angela, thank you so much for the $20 Cash App. She says, keep showing up. Oh, that's nice. That's a Nan quote. I love that. That was very sweet. Thank you so much. And again, 25% of all donations will go back to be kicked back to Karen Reed's defense fund tonight. All right, let's keep going.
There were many instances when I reviewed this trial where the
There you go.
defense
It's right
came
there.
up the
You wanna see
sidebar, they had pictures, photos.
Good catch,
things they
Mary.
didn't
Thank
turn
you.
over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery.
Beatrice says
Quote,
meltdown incoming. Here it
even-handed
comes.
discovery
I
to
haven't
both
seen this
sides
yet.
will improve both the administration.
All right, let's back up in here a little bit here. Let's see.
Reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up the sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes there are names on them, talking about theories of the case. I give it to the defense because it's in my possession, custody, or control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to...
How about this? You have a fucking obligation to give the original Sallyport video that we've been asking for weeks and months, and stop piecing in more videos that just pop up throughout this entire trial. Oh, here's something we found. Oh, by the way, your first trial ended, but here's another piece of video that we found.
Yep. We want all the videos.
Yeah, we want everything. Give the evidence up front, sir.
With the original copies.
Yeah, original copies. Stop cutting it up and throwing, making it inverted, reverted, upside down, inside out.
Missing time.
What's the thing in Netflix? Not Netflix. The Stranger Things. The upside down.
Oh, the upside
down.
down.
Want the upside down.
No.
Like, what the fuck? It's crazy. It is so crazy.
And wouldn't something with missing metadata automatically mean it was tampered with?
Yeah, I'd say. Yep. I'd probably
we were talking
say.
about that earlier. Like, oh, where's the metadata?
Yeah.
Well, that means it was manipulated if it's not there.
Unbelievable. All right, let's keep going here.
simply hide information because they think
Ian
it's
says this whole
impeachment.
trial's
That
upside
trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery.
$2. A lot of New Zealanders watching.
Yeah.
This is cool.
What
This
time is
very
it there?
What time is it in New Zealand? We had Aussies. We have a lot of Aussies in the
Yeah.
room tonight. We have our New Zealanders here as well. It says, FY, it's New Zealand money. Thank you. And says, I emailed you the link. Well, I will check it out after this
Thank
live.
you.
Thank you. By the way, I watched a video the other day. It was crazy. I don't know how it came in my algorithm, but and forgive me, I forget the channel. But this guy is an outdoorsy guy in New Zealand, and he goes fishing a lot, and he has a kayak, and he goes into the ocean. He went into an area of the ocean where it's just about right where great white sharks would be.
Oh yeah.
And all of a sudden he's fishing, and he goes, "There's a great white," and you see literally the shark come up out of the water, and he's like, "Shit, shit," and he starts taking off. And that shark is fucking following him.
That's terrifying.
And the thing was, I'm telling you, if you can find the video, the thing looked like Jaws. That's how big it was. And he's just paddling away. And he's like, I don't know what to do.
Yeah.
He's talking to the camera. I don't know what to do. And he's like, I know this is littering and I'm so sorry, but I need to get this shark off my tail.
Yeah.
So he took his water bottle and he threw it. Shark ignored it, kept
Really?
following him. He finally had to go paddle for another 40 minutes. The shark continuously stalked him. He got into shallow water and got up on the beach, and he made it, like didn't get bit.
That's
All that
terrifying.
shark had to do was tip his boat, and he would have been
Game
done.
over.
Game
Yep.
over. It was crazy.
That's such a fear of mine, sharks.
It's great. It's crazy, cray. He's like, there's a great white. He went great white, and that's it. It's insane. But anyway, back to Karen Reed.
The order of the court at the first trial,
Saturday
although it
afternoon
wasn't
in New Zealand.
followed religiously,
Oh.
was that reciprocal discovery was an obligation of both sides, and that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by
Uh-oh.
It will be.
Uh-oh. We can't hear what's going on in the court because you keep interrupting. Can you play it and give your commentary afterwards? We can't hear what they're saying. You keep interrupting. Well, I'm going to let you know, put the fries in the bag. Guess what? It's a live show, and this is what we do. We stop and we talk. And if you watch any LawTuber, which I know you fucking watch, because Emily Baker pauses, Melanie Little pauses, and they all pause. Lawyer, you know, pauses, and they talk too. But if you don't like being here, and you don't want to hear me and Lauren talk tonight, and you don't want to hear our discussion, guess what? Get the fuck out of my chat room.
It's a live reaction
It's
video.
a live reaction show. This is what we do here. So obviously you haven't paid attention to my channel for 5 years, because this is what I've been doing. So if you don't like it, out. I just did the out. This is what I do. It's my platform.
So since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material,
By the
we
way,
should not make
moderator,
an exception for this team.
get rid
We
of them.
provide it like everybody else.
They don't have to be
So
here.
I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it'll be abided.
Kay said this is literally the whole point of what we're doing.
Okay.
Yeah,
This is what we do. We
Is
discuss-
there any follow-up to that? The motion for
During the
sanctions will be a
trial.
little bit
What
later.
do we do?
The only thing I would point out, Your Honor, is that with regard to the report,
Always,
of
always
Jennifer
at least
McCabe,
one of them.
or Jennifer McCabe, I should say.
I have a guest
you know,
here
You're
tonight
being
that
rude
wants
to me.
talk. I have a guest here sitting next to me. This is my guest right here on camera. We're having fun. We're hanging out. We're raising money for Karen Reed's defense fund tonight, and you're trying to screw up my show. Get out of here.
revealing this link meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was
What we just
going
said.
on. So I just wanted to make that.
All the stuff coming in, just floated in.
I've tried my best, and I will continue to provide all discovery timely to the defense.
You've been saying that, and you haven't done it, dude.
Decide where late discovery comes in a trial. And I never want that to happen. Sometimes exceptions happen on both sides. But that is not the
So
intent of the
nasally.
Commonwealth. The
Yes,
Commonwealth
nasally,
is
more
trying to
nasally
make it
than me.
possible to give the defense more discovery than they're entitled to as early as we can.
All right. Thank you. Next is paper 495. This is defendant's motion to compel discovery. And then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Yes. Liza. Let's give us some
Your
Sandra
Honor, we filed a
Burchmore.
motion to compel certain discovery that is still outstanding. There's 10 items. I'll address those in turn. The first request deals with.
So you have the Commonwealth's response, right?
Yes,
Where it doesn't object to some. Are you going to skip over those? Or
Yes, of course,
okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions, one before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage.
That's important.
Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial
He's the
in this
best.
matter.
Yeah, such a
In
sweet.
that production, we have video surveillance footage from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside the Canton Police Department.
Yeah, I was ordering pizza.
The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's,
Thank you, Kelly.
review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those 3 productions, or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right?
Yeah.
We have Canton police officers who handled this footage.
Right.
We have Massachusetts State Police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence
Have a
that
good
they're
night,
admitting
Bob.
in trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos, but that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra
Here we go.
Burchmore.
Matthew Farwell.
There's certain
Insert
names
in
that
the
this court will
feds.
recognize. First responding officer, Sergeant Link.
Oh, I love this.
Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper, Garino. Lieutenant Brian Tully. Trooper, Kathleen Prince. And Norfolk County District Attorney, Michael Morrissey.
And what are they all got?
All
in
of these
common?
individuals are material and
Tell us,
relevant
Liza.
witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell
And
in
they
the murder
covered
of
it up.
Sandra Burchmore.
Yep.
The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer.
The brilliance of this right now, and this is what I talked about at the beginning of the show, and maybe you all agree with me here because you've had a couple days to opine on this. I'm finally just sitting down to watch it. But the brilliance of this, what I love, you've got all those officers now implicated. And what did she say? It's under a federal investigation.
Yep.
So now she's inserting the feds.
Yep.
And that is the one thing that they've been trying to keep out of Karen's case in all of this, the federal investigation and the federal information. This is all, no matter what happens at the end of the day, I want everybody to realize this. And that's the beautiful thing about all of this. It's all on the record.
Yep.
It's now on the record. It's there. It's data. It doesn't go away. It's information and it's there. What they choose to do with it is in the judge's hands. And we know what she's been doing in this case, but it is there and is now on the record. Love this.
Who should have been a suspect.
Clara, thank you so much for the 10. Appreciate that.
Specifically in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Burchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Burchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Burchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again, deals with the clearing of a fellow officer. And I would say one example, Your Honor.
Thank you for being
example,
a 3-month member. I
Massachusetts State
appreciate
Police
that.
Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Burchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Burchmore. No evidence of improper conduct. Nothing to see here.
But let's just skip the 25,000.
The federal investigators looked at the electronic data.
Right here, you're talking
They
about.
recovered tens of thousands of text messages.
25, I think it was over 25,000, right,
and
Mizzy?
Farwell that implicated Farwell in her murder.
Mizzy, was it 25 or 30,000 text messages? Let me know in the chat. I know the number was extremely
I feel
high.
like it was in the 30,000.
I think it was like 30,000.
Something like that.
You
Yeah.
could be right. Yeah.
The text messages, which are publicly available and
32,000.
referenced in federal search
Yep.
warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us?
So, from what I'm remembering about this, and I don't want to say relationship because it was clearly this guy
He groomed her and took
did all
advantage
this
of her.
nasty stuff to her.
Yeah, that's not.
Is it true? And I could be wrong on this because it's been a little while since I've been through it. I think it started back as young. She was like 14.
I think she was 14.
14 when this started. This guy's an ultimate predator.
And I think
nasty.
I think it turned into something more physical when she was 15.
15.
Yep, a year or two later.
So Mizzy, 32,000 plus.
Yeah.
Wow. Just
how do you miss
let's ignore that?
Yeah.
No, it's just we'll just ignore this.
Yeah. Look away. Look the other way.
Exactly.
That the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case.
Mm-hmm.
If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So they want to find out if they're jerking around in these hearings.
Yeah.
That's exactly what they're doing.
Yep.
Are they just bringing them in? They're jerking around. They want to see documentation of what's actually going on inside these hearings. This is a brilliant move.
Yeah.
This is brilliant because they could just be jerking around. So let's see some documentation here.
Mizzy said
Rule
she's actually
17 instead of Rule
12.
14. The third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests.
Oh, let's see what the tablet. Look at that.
As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right. Mr. Brennan.
It's important to represent facts accurately. And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked for chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request, I would look into any.
I missed the best part. I'm trying to get through this, Mary, because we got about like another hour. I know they're going to have that sidebar or that break. I'll go back and watch it after. because I'm trying to get through it. Here we go. Thank you, though. I'll go back and watch it after.
And I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot.
All right, I'm eating a piece of white chocolate and I'm enjoying it. It's really good. It's cookies and cream. It's great. I was hungry. Amr Valesi, thank you so much for the $10. And I'm sorry I'm being rude. I'm eating on camera. But anyone else think the two things happen at once? Hank gave the lie of the moment, and Bev got tipped off on the other news. She delivered the line, grave concern, but that's all she could do at the moment. It's a good theory.
Yeah.
It's a good theory.
Yeah.
Okay. Let's keep going here.
Invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have.
That's a good point, Julie.
It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth.
So he's pissed.
Mm-hmm.
He's pissed because he probably knew that Liza was going to get up and make that argument.
Mm-hmm.
And now he's like pissed that now I got to talk about the federal investigation.
Yep.
Yeah, he's pissed. You can tell he's pissed.
Implying somehow something's nefarious.
That's what they don't want to talk about.
That these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words.
Oh, amazing.
Our
We're in a
audience is here
sidebar.
on our right.
Oh, great. Thank you. That's
Try
all.
to create an illusion of impropriety.
The support.
There is
The
nothing that
sidebar
they have
t-shirt.
provided about
Oh,
the
nice.
court
Yeah.
case that will provide a basis for the Commonwealth to then now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Burchmore case, troopers, the DA.
He's trying
Yeah,
to
he's trying
the way
to
they
brush it
want
yeah,
to.
brush it off.
But when you're arguing a discovery motion, there must be a factual basis for it. A
Oh,
factual basis.
How is it not
He's so
factual?
swarmy.
We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none.
In tonight.
No
Thank you,
factual
Jim.
basis,
They say
no good
we
faith
love you
basis,
talking
because they want to
Thank you.
entertain our audience.
What we're here for. And law.
And so the reality is the Burchmore case is being investigated.
He
by
sure is.
federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Burchmore was a victim.
Uh-huh.
Yeah. That your police, in this case, covered up.
For
A victim of the
Hanky
police
spanky.
corruption.
unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Burchmore case. Why? Why that case?
You have to ask why.
Yeah.
Troopers work on many cases. That case certainly has a public appeal to it
I'd
Yeah, you
say.
because of the harshness of it, the sadness of it. But what does it have to do with
Horror.
this case? Nothing. But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor.
I mean, we know she will.
Yeah.
5,
But she sides with the
communications,
Commonwealth.
documents.
Always.
But you know, he may get his way here. I don't know. Piney Woods, Lauren Crime. Thank you so much. $50 super chat, and 25% of that will go back to Karen Reed.
Mhm.
So thank you so much. And we'll get the total at the end of the show. And what I usually do is when I make the donation, take a screenshot of it and I'll post it on my Facebook page and on my YouTube community page to be transparent. And also you can go in there and you can monitor the donations as well.
Yeah.
And I'll put something like LTL Media Chat Raiser.
Yeah.
That's kind of what I do. And I date it so you know it's transparent and it's up there. Piney Woods Law and Crime, $50. Thank you so much.
Thank you. I'm
Says,
tracking.
Perfect. All of the things he said about no logs, chain of custody, etc., that authenticates evidence. If evidence is not authenticated, like metadata, it's not admissible. None of it should have come in. That's on Bev. Great explanation.
Yeah.
I love that. Great. And I love the fact that you could break that down in very simplest terms for people that are not super lawyers here.
Yeah.
And they're just interested in these cases.
Yeah.
And I completely agree. And you are so dead on about that. Thank you so much. I appreciate that. All right, let's go.
Reports memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel.
Christina Rex.
And they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage.
Yeah, I see a little bit of his laptop.
In this case, whether they're exculpatory or not, even
Funny,
material irrelevant.
right next to
And I
him.
agreed I would do that upon request. Now that call has not been set up by the defense, but when it is, if it is, I will be there.
Sure, we can get a total
for them for this information.
So let's see. We're getting a total so far. If you want to add those,
Over 600 now.
All right. And then we're going to do 25% of that.
$655 so far.
655
So
minus the 25
times 0.25 is $163.
Okay.
Rounded up.
I'll most likely, if we don't get any more, I'm going to probably round it to 200.
Oh, yeah. That's
usually
even
what
better.
I do. I round it up to the closest. So about 200 right now. Kick back to the defense. All right, let's keep going here.
There's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady v. Maryland in Giglio, and most recently set out in McFarland and Graham. The Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth v. Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024. Please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but
Jill Daniels.
17 motion and will continue.
Look at Aiden's computer.
By our obligation.
Jill Daniels
Oh, I
she
see
was
it now.
screaming at him outside of
McCarthy's. Yeah, I remember that over the summer. I remember watching that.
Number 6 and 7, we do not object.
She assaulted him.
She
Number
did.
8,
Phone out of
Right
his
on
hand.
camera. Yeah.
between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there's a difference between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided
May, thank you
all of our
for 5
materials
gifted memberships. I appreciate that.
for
Welcome to
all
new
of our
members.
experts. The discussion between the experts, the oral discussion between the experts and me
Dream team, thank you
cannot
so
be
much for the
replicated.
$10
If
super
anything
sticker. Appreciate that.
or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA, and again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week, and I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that
thank
under
you.
advisement.
$20. I love that name, by the way.
Do you have that
Thank
Rule
you.
17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're over 500 at this point. So.
Yes.
All right. All right, so next we'll move on to the so-called ARCA motion, Commonwealth's motion to exclude employees of ARCA, paper 497, and the opposition 505. So, Mr. Brennan? Sure.
I just want to pause this for a second and just talk about something really quick.
Yeah.
You know, to the audience and everybody that has been through everything that we have pretty much been through in the last, for me, it's been like a year and a half. But some people have been here since like the very, very beginning when Turtle Boy cracked this open like 2 years ago.
Yeah.
And I want you all to understand is that you've all made a significant impact in this case. This is a huge cultural awareness of what's going on here in Norfolk County, especially here in Massachusetts, and how we see it inside, how we see it and analyze it. You know, I'm here, I'm in the thick of it. You're here, you're in the thick of it. You know, you've been out to standouts.
Yep.
I'm sure you're going to be very present during the trial that goes on outside supporting. But this is such a amazing cultural movement that we have an opportunity here to change, hopefully change a lot of things. And I go back on that headline from Howie Carr that Karen Reed will be acquitted in 2025. I firmly believe that. I know she will. But I'm just so impressed with the level of intelligence that I see in these chat rooms, how quick everybody is to answer, how they analyze all this data. And believe me, we go through a lot of it too. And sometimes we forget we're human beings, but
it's a lot to remember.
It's just impressive what I see here in these chats. It's so impressive, you know, in the Facebook groups and on Twitter. And I love the conversation, and I love seeing how different people break this down. And even I like looking at like the free Karen Reed people because I
Yeah.
like to see what shit and nonsense they spit out.
Yeah.
And kind of get a play of like where they're standing with all of this.
Mhm.
But I am so impressed and so proud that you've all been here and hung in so long, because
Yeah.
I go back to the conversation that I had with Alan Jackson when I was I had and we're looking at the photo right now,
Yep.
the opportunity to go in and sit in that day in court. And he said, you know, in a summary,
Mhm.
if you all weren't here
Mhm.
doing what you're doing, this case would be completely different.
So different.
Completely different.
Mhm.
So thank you. You know,
Yeah.
I just want to say thank you, and thank you to everybody here
It matters.
that has been here, and it does matter.
Every single person that's part of this movement has done something. Every time you go to a standout, it matters. Every time you talk about it, it matters.
Yeah.
I've been following this for. I watched the YouTube video when Turtle Boy first put it out, but I was kind of more of a casual follower.
Framed.
Yeah,
Watch
framed.
Frames,
Yep.
yeah.
And I was a casual follower until the trial last year, and that's when I really started watching it and paying attention. But I was living in Virginia at the time, and
Mhm.
now I'm up here, and so I'm trying to be more involved. And
Yeah.
I go to more standouts, and I want to be at court. So everybody matters. Everybody
Everybody matters. I completely agree. Stelly Arts, thank you so much for the $20 super duper duper chat. I appreciate that. Kathleen's been a member for 12 months. So
Thank
let's celebrate
you.
that. Thank you. You keep the lights on here in the studio so I can continue to do this and talk about not only the Karen Reed case, but many other cases that we talk about on this channel. So that does help. And she says, thank you. I said, no, thank you.
Yeah,
Thank
thank
you
you.
for being here. All right, let's keep playing through here. And thank you for being here, because this makes it like, this is what I wanted to do. That's why I built this damn studio. I have people come and sit in, and I don't care if they want to be on camera, they don't want to be on camera. You know,
Yeah.
Lauren's been a little under the weather. She said, I'll go on, but let's just do Mike. I said, it's fine. Just come hang out and be on, because we have this is what I mean. See what
Organic
this sparks? It's so much
conversations.
organic to do this. I love the virtual stuff, but to have people come in and sit down, it's such a treat. And I just like hanging out with people and talking.
Yeah.
So this is cool, you know, and you got to come back and
will.
hang out. We'll do more of these.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government, and they provided a report to us pursuant to a CHUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials.
$4.99.
But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information.
March of 24. So when was all the federal information provided? That's what I want to know.
I don't remember that specifically.
I apparently was supposed to have all this done in lockstep, but I'm sure that someone in the chat room will know it. I want to know when all the federal information was provided to the Commonwealth and the Reed team.
Let's see.
That's what I want to know. Someone will know it in the chat.
Yeah.
So
February
of
24. The month before.
Okay, so I've just proved my point.
Yeah.
This is all a bunch of bullshit. They knew.
Yep.
The Commonwealth knew. So the Commonwealth knew.
They always knew.
Right. And TUI was provided in February. So they all knew about this. Yeah. This is to my point. This is a farce. This is fucking
ignorance.
smoke and mirrors what he's doing right now.
Mm-hmm.
Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward.
In the federal office.
Now, it's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd.
They're not entitled to a fair trial.
Yeah.
Only the defendant. Like Nan
Alan, I
said.
spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
Yep.
Now, this is
Man,
information
that's
provided.
right. Yep. Great point.
Yep.
Nan says, let's not forget the Commonwealth had equal access to ACA and chose not to. They had all the information in February.
Yep.
They want to push this aside. They don't want to listen to the federal investigation. They're just trying to make this all go away. This is what this comes down to.
Yep.
That's what it comes down to. I mean, look at what has he attacked? The most credible things in this. Dr. Russell.
Yep.
Okay. ARCA. Okay. What was one of the other arguments they had that was a key point? Tried to get Russell out. He's been trying to get ARCA out. The feds. He's trying to now get the feds out of this. And there's many other things that he's done.
All the key evidence.
That
hurts them.
Yep. That hurts the Commonwealth case.
Municipal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistence.
Sallyport video.
All the video nonsense.
All the video nonsense.
We then are provided an outline of questions and answers for a direct examination.
Green. Yep. Someone said
Commonwealth did not
Green.
have the luxury of
Richard
privilege,
Green.
did not even know that there was an outline.
Oh, the
that was
Google
being
search?
disseminated by this
Yes.
totally
27. There's so many things.
witness who took no side other than that of the truth. What follows from this outline
Yep. You're right.
is then
Teacup.
the outline with remarks from this independent expert who knows nobody.
Excuse me.
So we see in the margins and the notes, this fair-minded, objective witness says,
Now, I also want to make this perspective too. We've just sat here for the last 8 minutes of Hank talking about this. Have you seen one person at Karen Reed's table rattle, move in a weird way, or feel that something's going to happen here? Yeah, they're not even scared. They're not swarming.
They did nothing
They
wrong.
know they did nothing wrong.
So not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue. I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter.
It's shaking a little bit.
The date of that?
Actually does.
It's not dated. It's not dated.
Oh, good pickup there. I saw that. Let's go back a little bit. Oh,
That's interesting.
That is interesting. Watch his hand at the podium, people. I saw it too. I'll point it out with my
the best I can to get as much information as I can.
Let's
Then I provided an outline.
Curious.
An outline of questions and answers.
voice
for a
is
direct
shaking right
examination.
there too.
Yep.
The Commonwealth did not have the luxury to privilege, did not even
Shaking
know
all over the place.
that there was an outline that was being disseminated by this totally
It's interesting who's showing signs of anxiety right now and who isn't.
who took no side other than that of the truth. What follows from this
Shaking
outline
right there too.
Yeah,
Good
he is.
point out.
then the outline with remarks from this independent expert who knows nobody.
See his hand.
We
is
see in the margins and the
Mhm.
notes,
Especially when you zoom in, you can when they
fair-minded, objective
really see.
witnesses.
He is
Yep.
nervous. Ellie.
Yeah, he
Being able
is.
to inspect the
Look at
vehicle
that.
is something that's not uncommon in your line of
We're
work.
gonna
And he writes,
shake.
absolutely not.
Yeah.
And he comments,
Watch
not
this
sure if you
hand,
want to
too.
put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue. I didn't personally inspect the vehicle. I had enough
hand is
information
Yeah.
from the
shaking.
material I reviewed, so it wasn't necessary.
Tell from the paper, yeah.
Need to show the jury it doesn't matter.
Watch his hand here.
The date of that?
Wicked
It's
shake.
not dated.
Oh yeah.
It's not dated.
Right there too.
Riddled with
TUI request
anxiety.
is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time
Everybody
of day and
catch
pedestrian fatalities.
More.
Statistically speaking, most pedestrian fatalities occur during the evening.
Yeah,
and
maybe
night.
someone can point that out to microdots and they can bring up the video and cut that.
Yeah.
So I would say, maybe I'll reach out let's write this timestamp down, like 1:13.
Okay.
And I'll reach out to Microdots and maybe
Yeah.
we can get a video of Hanky Spanky shaking. and we'll have him zooming in so everybody can see.
Night hours. That would have been nice to have.
That was a good point.
So
Outlaw.
my specialty in the area of lighting and human factors results in a lot of my cases. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them.
What was that?
What was that?
Have you qualified as an expert in
Don't
corporate
tell
law?
him.
Yes. I realized my testimony, I said it 20 times. When you asked how many I've been qualified, I misinterpreted the question. My fault.
We said with
11 trials,
point
7
that out.
depositions.
Lauren
Not sure if
actually
you want me
caught
to
it.
clear that up.
Yeah, that was all
That was
me.
all Lauren.
I
He's
don't know if it was
shaking
ever
right
cleared
there too. He's shaking.
Yeah, he is.
And then a bill
That is man is scared.
from ARCA to the defense for $23,925. That's not trial. That's not trial by ambush. That's getting duped.
Yeah, that was hilarious. Trial by
So
hand.
I didn't know any of this, but I've tried a few cases.
Why do you
I've
fuck
been around the federal court a little bit. I know how it works.
Oh.
Sometimes parties pick sides.
Okay.
It's an imbalance and unfairness.
This guy's all
And
about
it allows the ability to one side to use
He looks like
ghosts.
he's auditioning for a movie.
Yeah.
Create
He's
illusions
awkwardly
and
reading.
chills and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions. But I
We
care
do.
that it's
Yeah.
unfair, imbalanced, and hidden.
Oh.
And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I will welcome
Look
it.
out! Look out!
I'm going to take a recess.
These are ridiculous.
I'm gonna take a. She needs a White Claw.
Yeah. For her weekenders.
Her weekenders. She needs weekends too, Lauren.
Yeah.
She needs weekends too.
Yeah.
I need my weekends.
I love having weekends off.
All right. Yeah. Great
The
point out here. ARCA picked the side of science.
Yep. Good.
That's right.
That's so right, man.
They did. And if anybody ever watched the video when I go out to Plevin
Oh,
and I'm
yeah,
talking
that's a
to
good
him,
one.
and I ask him, do you believe in physics?
Yeah.
And
the
well, actually, no, I
Earth is
said,
round.
do you think the Earth is round? And he said, it's
Spherical, yeah.
That's a what do you say? That's a very offensive question you're asking. Spherical. And I went, it's round, dude.
Yeah.
So how are you denying physics? And he had blah 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 blah. So anyway, we're gonna speed this up, get back to the hearing here, and let's catch up and we'll see. She's gonna go,
I have a grave concern.
a grave concern. Start shaking. Another shaker. Oh wow, they did take a long break. All right, here we go. All right, let's get back. Dog Lover, thank you so much for the $2. I hope everybody enjoyed this this hangout tonight. Me and Lauren hanging out, and it's been nice to have someone here and have some back and forth organic conversation. And if she wasn't here, she wouldn't have picked up Spanky
Shaking in his
at the
boots.
podium. His boots. That was a good pickup. Jeno, thank you so much for the 4-month membership. The DOJ paid ARCA the $26,000 on 6/12/24. Exactly. We know where it is. We know what's going on. All right, let's hear the meltdown. Gen X says it's
I've been waiting
meltdown
for
time.
this.
Yeah. Thank you all for being here. Tap that like button if you haven't. I would appreciate it. Excuse me.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today
Your White Claws.
at 11 o'clock in the morning. You can tell me now if that is impossible for you.
Party on, Wayne. Party on, Garth.
Look at her. Oh my God. She's shaking
And
too.
where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government.
Wait a minute. He made an error. He made an error in his motion. He said, I think I said defense, but I meant the feds.
We filed the motion to exclude February 13th. The defense provided us the emails that I read. February 13th, 2025. I think I said the federal government. It was the defense. February 13th, 2025.
Federal
They sent
government, but it was actually the
emails
defense.
and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
Real quick, just get to this. Brit Flip, thank you so much for the $5. Hoping the O'Keefes realize Karen is doing the actual investigating. Also, Breath, thank you, LTL. Thank you so much. I can tell you that she is so active in her case. I had the opportunity to sit down with her in August with Dave Collinet. And we got to interview her and ask her pretty much anything we wanted for 3 hours. And she did not shy away from anything. She said, ask me whatever you want. I will let you know. And she knows this case like an encyclopedia, like that Encyclopedia Britannica.
Yeah.
She knows. Yeah. She knows everything. And she's very heavily involved. And I have to say, in all my time of knowing about cases and defendants, I hear more about how in tune she is with her case.
Yeah.
You don't really hear it much in defendants where they usually just go, here's lawyer, take over.
She's
but
so
she said, even in the Ted Daniel interview, we get in a piece of information. I'll run it by the attorneys. We'll go through it. We'll scrub through it, come to a conclusion. Is it relevant to what we're looking for? I mean, she's heavily involved. Yes.
Yeah.
A photographic memory for sure.
Yeah. Jackson
100%.
said she has an analytical mind in the interview.
Yeah.
He said, and it's true.
Yeah.
She's so smart.
Yep.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
Here, if I may hand up the discovery that was
Thank you.
provided by the defendant reference guide.
Oh, great, thank you.
Is there any way we should use this for today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th, even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
Take a red eye.
Yeah, we'll take a red eye.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we could do it live, I'd rather do it live.
Do it live. We'll do it live.
Calendar.
Fuck it. We'll do it live. Bill O'Reilly.
Yeah.
Great
Are
court.
all parties available at 9 on the 26th?
I'm not. Nah, just a moment.
Thank you, Jim. Jim. Thank you.
Thank you.
So wait, there's an interesting question going on here. So Jeno asks, weren't they both allowed to engage? Thought the email said both parties could. And then Nan answers and says, Jeno, if Hank was correct, yes, this could bar the experts and kick AJ out.
But he's not correct.
Let's say he's not correct. I have a theory. We're going to talk about it offline.
Okay.
After we end this.
Okay.
I got a theory going on right now.
Very interested to hear it.
It's a good one. It's a lot of timing going on right now.
Yeah.
I'll just give a clue. There's a lot of timing going on right now of attorneys.
Nan just said, notice how calm Bev is now because Bev realizes Hank misrepresented the facts.
Everybody wants to hear it. I can't. It would cause a lot of people to be like, fuck you. But I'll talk to you about it after and we'll mull this theory.
I've had many conversations about different theories.
Yeah. All right, let's play through and finish this. We'll give a total and we'll make a donation. His glazed donut.
Is he scratching his nose?
He's scratching his balls. His hands in his laps.
Worse.
Oh, I missed the other question.
We'll accommodate the 25th.
All right. Let me go back up. Is it up? It's probably up further. I hadn't gone so far now. Jeno. Let's see. Jeno. Nothing like stopping the show to. Is it true that would preclude the defense? There's probably some more I'm missing. I'm too far up now. I'm sorry, everybody. All right, let's keep going here. Let's try to finish this.
All right. So we'll see everyone.
Drive back.
I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock on the 25th.
Thank you.
All rise for the vote, please.
We got our fan. We got our fan. All right. All right, Mr. Jackson.
That looks like what the total is.
Great. So Lauren just totaled up. We're at 544. And then what are we doing? 25% off that?
It would be times 0.25. Yeah, something like that.
408. What do you got? 54. 408. We're at, really?
Yeah.
That's it?
Yeah.
We're at 136, but I'm going to bump it up to $200.
There you go.
So we're going to donate $200 to Karen Reed's defense tonight.
That's awesome.
We came up with a total of 544 between all of the super chats, all the cash apps, the Vemos. So
I don't have the cash apps or Venmos down here.
Oh, you didn't do it?
No, I
Okay,
don't
here.
have those
I'll give them
listed.
to you.
There you go. So
That'll add too.
Yeah.
So add 25.
Okay.
Add 20.
Okay.
Add 25.
Okay, so now we're at 614.
614. Take 25% off that. Probably close to the
153.
153. I'll
Yeah.
go to 200. So we'll do 200
awesome.
tonight. Back to Karen Reed's
100
Defense
to
Fund.
Karen.
200 to Karen. I'll make that donation when I get offline. And then just for transparency, if you're part of my Facebook page, LTL Media, I usually post the receipt up on there. And I also post the receipt on my community post on YouTube. And then you can actually just go right to the defense website.
Yeah.
I'm going to put LTL Media chat raiser.
Yep.
And I'll put the date and then we'll have the donation there. So $200 tonight. So thank you, everybody.
Awesome job.
And I just want to get this really quick. Nan Fierro says, in a nutshell, if the defense violated the order and substantively communicated with ARCA and paid them, then it could be grounds to bar ARCA and kick Allen off the case. It's funny because I kind of threw this. I don't even know if I still have it up there. So I threw a portion of an article that we read because me and Lauren were trying to figure this out when we came here about what was going on with Alan Jackson, and I threw it into ChatGPT to see what kind of answer we would get. And I asked, would Jackson be in trouble? And basically, the portion of the article I threw in there was a quote from a former judge, and they said, if Mr. Yannetti does not know about Mr. Jackson's invitation for engagement letter, retainer request, and all in a possibly a bill in Mr. Jackson's possibly small preparation of the witnesses, he cannot fairly be held responsible. Lou explained. The same analysis holds true if the question is whether they violated a continuing duty to disclose any of the information and not disclosable information exists at the time of Mr. Yannetti's statement. We do not know the facts, but as an attorney discipline matter, it is unfair to penalize valuable lawyers acting in good faith for technical violations. So I threw that into ChatGPT and said, would Jackson be responsible?
Yeah.
This is what it spit back. Any lawyers in the room? Correct me if I'm wrong. Correct ChatGPT. Here we are. It's the ChatGPT answer. It sounds like the situation revolves around whether Mr. Jackson might face disciplinary action or trouble for potentially failing to disclose certain information, particularly about the engagement letter, retainer request, or witness preparation. Based on Lou's explanation, it seems like Jackson's action would not be viewed as an issue for attorney discipline if their relevant facts aren't present or disclosed at the time of Yannetti's statement. If there is no intention to conceal information or no violation of it, continuing duty to disclose occurred, then it would be unfair to penalize him. Yeah. If Jackson generally did not know about the details and questions and acted in good faith, it is likely that he wouldn't be significantly in trouble. However, this analysis assumes no intentional wrongdoing and that the technicalities in the question do not raise the level of violation or legal ethics or professional responsibility. Ultimately, if the facts show that Jackson is unaware of key information or acted without malintent, he may not be in trouble, but it would depend on the exact details and circumstances of the situation. Yeah. I believe it. I think I'm gonna believe Jody here. And I said this at the beginning of the live. There's no fucking way that Alan Jackson, everything he's been through with Karen, and this defense team has been through with Karen, would never put her in a position to harm her case.
No, that's
I
ridiculous.
don't see it.
That's ridiculous to no, that's absurd. I don't believe that at all. I don't believe
There's no fucking way.
No.
And I think that Hank is going to have something coming to him on Tuesday when this is all explained and all the documents are there. And again, I think he's going to get shot down and he's going to look like an asshole again because that's all he's looked like through this entire process.
Yeah. A nasally asshole.
Let's see. Jeno and Nan going back and forth here in the chat. But so what do we came? We came to $200.
Yep.
I'm going to donate $200 to Karen Reed's Defense Fund tonight. We're going to head out here because it is getting late.
Yeah.
I got to work tomorrow. She's going to drive back an hour back towards Boston.
Yeah.
So thank you all for being here. I appreciate it. And we're looking forward to Tuesday, but I will be back here live, double duty on Sunday, 10 a.m. We're going to have Tom CPU and Boston Mike. I like a lot of the conversation that they've been having in their morning chats.
Yeah.
So I asked them if they wanted to come on and chat with me for a little while. So we're going to have a 10 a.m. show on Sunday. And then at 2:30 on Sunday, Mark Mazzamedia, losing my voice, will be live in studio on camera, hanging out. And we're going to have some fun and do some fundraising for Karen.
Yeah.
Let me turn your camera on. Any parting words to the audience? I'll let you jump in there.
Oh, thank you for having me on the show tonight. It was fun. I didn't expect it. It was a little surprising, but I was like, okay. And I had a really good time. And I had fun chatting with everybody. And I'm sure I'll be back.
And if everybody wants to know what it looks like in here and you haven't seen it yet, I'll just kind of spin the camera around. But this is what it kind of looks like. That's my camera right there. I just ordered these seats. So when Mark comes in, he's going to sit here. We'll have a camera position on him to hang out. And this is what we look at, you know, when we're up in here. And it has
it's nice in here.
Yeah, my photo with Karen in the defense team is over there on that wall, as you can see. And we have a little entryway as my punk rock poster. and we have in there, just in front of the punk rock poster, got another TV in there. There's a small love seat. You can come in and watch Netflix or whatever and just hang out like it's a little green room. It's fun. And I'm completely blessed. And this all would have never happened without this audience. You know, you all have made this happen in here. And I love being in here, you know, and I have, and I said this before. Just up over the door.
Yep.
If I can get my camera here to turn.
Never give up.
It says never give up. And that's on my threshold. And then on the other side of the threshold, when you come in, it says
the best is yet to come.
The best is yet to come. So it's fun in here. I wish I had a little bit more room, but we make it work. And that's what we do here.
Yeah.
So again,
great show.
Thank you all so much. I'm going to make a donation right now before we get out of here. And I'll post up the receipt on my Facebook page, my community page on YouTube. And then you can also vet me and just go right to Karen's Defense. And you'll see LTL Media Chat Raiser. We'll put the date on there, 2/21/25. All right, everybody. It is late. We've been here 2 hours and 36 minutes. I appreciate all of you. Lauren, thank you again so much for coming and hang out.
Yeah, thank you for having me.
Next time, let's have you in. We'll have you on camera. You can come hang out. We can do this again.
I'll be more prepared.
Cool. We'll do this again. And I'm going to head out. Good night, everybody. If you haven't subscribed, please subscribe to the channel. Like, share, subscribe, comment. Let me hear your thoughts on this hearing. Again, we have another hearing coming up on Tuesday, and we'll do this again.
Yeah.
All right, everybody.
Have a good night.
Have a good night. Get some rest. Thank you for being here on this Friday night. I love you all. Gonna hit the outro. Good night. Peace.